Across Ontario, parents are facing a dilemma. Their children are being temporarily removed from school, not because of behavior, but because of medical information disclosure tied to wishy-washy public health legislation. It's called the Immunization of School Pupils Act, or ISPA, and it mandates the disclosure of what was once private, confidential medical information to third-party public health databases such as Panorama, systems that form part of a broader World Health Organization-aligned global disease surveillance architecture. This data, once centralized and digitized, becomes extraordinarily valuable. Detailed health records are worth millions on the black market, far exceeding the value of stolen credit card data due to their permanence and scope of intimate details and the fact that they cannot be canceled or replaced. Yet these government-run systems have repeatedly been shown to be vulnerable to breaches, hacks, and leaks, placing children's lifelong medical privacy at risk without meaningful consent or recourse. The question that we must ask is, under Ontario law, is this even allowed? And what about constitutional rights, children's privacy, and dignity? Today, we explore this with insights from John Carpay of the Justice Centre for Constitutional Freedoms. Have a listen.
Parents have the right to raise and educate their children as they deem best, and so there are limits on government authority. At the same time, governments do have the authority to promote public health, and that can include laws that encourage people to get injected with various vaccines. We saw a very extreme and I think very highly unconstitutional version of that 3-4 years ago during the 5 years ago when if you didn't get injected with COVID vaccine, you became a second-class citizen. But theoretically, if there is a particular disease that actually is very, very deadly, and if there's a vaccine that actually is effective, okay, then in that context, there can be laws in place that are valid, that whereby the government encourages people to get vaccinated. Now, the nitty-gritty of how legislation is applied, I mean, that's where, in that context, like a family would need an individual lawyer to look at the individual fact scenario, and get into that. But speaking broadly from general principles, I don't think that if somebody challenged this Ontario's Immunization of School Pupil Act, if somebody said strike it all down because it's promoting vaccinations by allowing the temporary but repeated temporary suspensions of students who are not getting vaccinated or whose parents are refusing to disclose the information. If you were to do, I think, a court challenge saying strike down this whole law because the government has no right to promote vaccines, I think that would not win in court as a broadly based constitutional action.
Although Carpay says that a constitutional challenge may not win in court, blanket suspensions for non-disclosure of vaccine records may stretch, if not break, constitutional boundaries, especially when they're being done without the legislation that binds schools to their mandate through the Ministry of Education, and that is the Education Act. So while courts may not overturn the law wholesale, that doesn't absolve the government from respecting children's rights when they're applying this act.
Governments do have some kind of a right to promote vaccines up to a point. The way that they go about doing that must also comply with the Constitution. And then you've raised a whole new area here, which is the right to privacy, which is part of our Charter Section 7 right to life, liberty, security of the person. We have privacy rights is a part of that, a right to be free from state surveillance. So when the government goes about its constitutionally valid business of having reasonable laws that promote vaccines as a public health measure, they also are required to do it in a way that minimizes the privacy violations. Now, what that looks like, I'm a dinosaur with technology, so I wouldn't stick my neck out to comment on, what kinds of databases. But speaking in terms of general principles, governments do have to operate in a manner that respects and protects the privacy of individuals. right? So they're allowed to pursue an objective, but they have to do it the correct way.
So here's the tension. Ontario law grants a right to education, enshrines privacy protection, and mandates that children receive specific stipulations for suspensions longer than 11 days. The problem is that the Education Act, the Privacy Protection Act called PIPA, and ISPA collide.
Too many laws, in my view. And so this is where it gets into, the detailed weeds of if you have one piece of legislation that says children have a right to receive public education free of charge, and then you have another piece of legislation that says people are entitled to privacy, and those laws exist. And then you have another piece of legislation that says, kids at public schools ought to get vaccinated against diphtheria and rubella, and there's a list of diseases there. And we're not talking about the new COVID vaccine that was rapidly developed in 2021, but we're talking about vaccines for illnesses that have been around for a long time. So you've got legislation saying kids ought to get vaccinated, and the chief medical officer can pull kids out of school for up to 20 days at a time. So it's contradictory, and that's part of the result when you have way too many laws on the books. But I think the best solution in the public policy is to have stop trying this one-size-fits-all public school system. That's really the root issue, as I see it. If government allowed parents to spend the education dollars, so the tax dollars are still spent on education, but it's within the parents' control to choose the kind of school that they want. Part of it is, I think, just it's false ideas that, this is all working out beautifully when it's not. In Alberta, we had a big brouhaha where the government tried to, and has removed pornographic type books from school libraries. And then school boards are saying, you want to ban The Handmaid's Tale by Margaret Atwood. So you have all these fights, right? And you have fights over drag queens doing story hour, and you have fights over the curriculum, and you have fights about whether or not you can put up a rainbow flag, or whether you're allowed to or should be required to. Fights, all this wasted energy that could be not entirely resolved, but largely resolved if you let parents choose how their own tax dollars are going to be spent on education by providing diversity in education. In a city like Toronto, where you have presumably hundreds of schools, just making a guess, there's no reason why you can't have a diversity of education within schools in Toronto, and not just the minimal diversity of Catholic schools versus public schools. You could have different schools that they choose to emphasize the sciences or the arts or music, or they choose to emphasize a language, German, Arabic, French, or they choose to emphasize academic excellence, or they choose to emphasize sports. You could have so much diversity within that publicly funded system and spending the exact same amount of money that you are now.
Directing policy reform aside, the impact on children in the right here and now throughout this process cannot be dismissed or diminished. These suspensions, threats, and coercion undermine not only educational access, but also dignity. It's important to note that while the legislation says that a medical officer of health may require a person who operates a school to suspend a student, which is the principal, it does not grant the authority to ostracize or intimidate families. Fair process is non-negotiable, yet often ignored in practice. And that's where homeschooling becomes the default, not simply a choice.
So the root problem here, I think, is it's a deficiency in the law. And I'll make another point, too, is that the law seems to, as far as I can tell, it authorizes this 20-day suspension. It does not authorize other tactics like ostracizing children and threatening parents to call social services. There's other things, to whatever extent they are taking place, it does not appear to be authorized by the legislation. The legislation says the chief medical officer can suspend the child for 20 days. that's it. Does not appear to be legislative authority for other tactics that schools could use against children and parents.
Sadly, principals and school boards have been known to ostracize children whose parents request that the Education Act be upheld, especially since these long-term suspensions often amount to nothing more than a futile exercise in isolation and exclusion. When parents who have not received a formal suspension order send their children to school in absence of them, some principals have confined these children to small spaces, denied them recess, their busing, or even involved police and or children's aid societies. Challenging these practices legally is costly and emotionally draining, which puts justice out of reach for many families. This allows these unlawful practices to persist because they can't be feasibly contested. It creates a system where compliance is enforced through exhaustion, intimidation, and silence.
Well, it's one more reason for people to take their kids out and homeschool. And it's unfortunate that for many people is something that they are, at least initially, they're kind of pressured into it. Although every parent in Canada turned into a homeschooling parent during the lockdowns when kids were sent home, often with very little notice, maybe 1 or 2 days notice or an announcement on Friday that kids are going to have to stay home on Monday, that sort of thing. It's not really fair that people are required to pay taxes and they're required to support a public education system which they may not wish to use. Once you get past the unfairness, though, if you think about what's best for your child, I think that increasingly, when you see the transgender ideology that's being pushed in schools from kindergarten right on through to university, and you've got the illiteracy and the failure to learn basic math, you've got the declining standards, you've got often not very much learning taking place. And now here's kind of, one more problem with this, what appears to be very heavy-handed approach that on vaccinations that seems to not respect privacy. All of it is pointing to, unless and until we get authentic diversity in education, it's probably best to pull your kids out of public school. The high cost of legal services is a sad reality because to start a court challenge on something, you're going to need to spend $50,000, $100,000, and over the course of a few years, $200,000, $300,000. That's what court cases cost, which is disgraceful, and that's something that should be remedied by, among other things, appointing more judges and with law societies actually serving the public interest by making it possible for people to access lawyers at a lower cost. Anyway, I digress. But people would need. Look, here's a simple and not expensive way that it does take some time and effort, but it's worth it. People need to contact their MPP. It's the provinces that are in charge of education. People need to contact their provincial elected representative and, ask for a meeting. You may or may not get a meeting, or write an email, make them aware. Because when a politician says that he has seen the light, it's usually because he has felt the heat. So that is a, very cost-effective, takes a little bit of time and effort. It doesn't cost money. People have to make their own provincial representatives aware and contact their own school board trustee and also request a meeting with the principal and sit down and go through it. Educate the principal. Go in there polite, low-key, calm, and explain to the principal. And I know it's a little bit intimidating. The principal's an authority figure, and if you're like me, maybe you got called into the principal's office as a child for some kind of misbehavior, so maybe you find it intimidating. But get over your intimidation. Ask for a meeting with the principal. Sit down and just politely explain concerns about privacy rights and ask questions. And so these are important things that can be done and should be done that don't require an expensive court action. In terms of if somebody does want to submit a request to the Justice Centre for the legal team to look at, we do receive online written submissions. The website is www.jccf.ca, Justice Centre Constitutional Freedoms, jccf.ca. If a parent wants to request legal help, then the form is confidential. It's looked at by lawyers. It doesn't go anywhere else. And people can write down the facts and circumstances, ask for legal help, and then, the legal team reviews it and then makes a decision from there.
What's clear throughout all of this is that Ontario's one-size-fits-all approach to school contingent on mandated medical record disclosure creates conflicts with constitutional rights, privacy, and children's dignity. So when the state intervenes in private health choices, how far is too far? And who really pays the price? For Rebel News, I'm Tamara Ugolini. If you'd like to find more reports just like this one, head on over to stopvaccinecoercion.com. You can sign our petition if you agree that vaccine coercion is wrong, and consider supporting this work if you are able to. All of that and more at stopvaccinecoercion.com.